Hello. So now we are going to begin our conversation about the appellate process at the Supreme Court. Remember that appellate is just a fancy word for appeals. So this is the appeals or appellate process at the Supreme Court. And we're going to talk about all the steps that it takes to hear a case and for a case to be concluded at the Supreme Court. And when we're talking about this process, there's also a lot of really important questions answered about how the Supreme Court functions. So, without further ado, step number 1. The court hears cases based on petitions that are filed by individuals or state governments or the federal government or corporations or groups like religious organizations. Now, this idea that the court hears cases based on petitions, meaning people need to fill out a form and send it to the court and say, basically, I'm paraphrasing, but they're saying, please, Supreme Court, hear my appeal. Now, that may seem like a very sort of inconsequential concept, that the Supreme Court hears cases based on petitions. But that means something very important, and it is this. The Supreme Court doesn't go out looking for cases to solve. It can't. It doesn't have the authority to go out looking for cases to solve. Cases need to come to them. Again, cases need to come to them. And the Supreme Court has what's called certiorari jurisdiction. And you can, because most people do, abbreviate that term to just the word cert. The court has the power of cert. And that means that the Supreme Court itself, meaning the justices of the Supreme Court, decide which cases they want to hear. So, there are about 8,000 or more cases that are appealed to the Supreme Court. In other words, there are 8,000 different individuals or corporations or government agencies, about 8,000 a year, petition the Supreme Court and say, please hear my case. The Supreme Court has the power to decide which cases they are going to hear. That is the power of cert. So of the 8,000 or so petitions rather, that they receive, they hear about, on average, 80 to 85 cases a year. That's it. Now it takes not 5, but 4 justices to decide that they want to hear a case. And then, if those 4 justices of the 9 total say that they want to hear the case, they're doing what's called granting a writ of cert, and they say, sure, we'll hear your case. So it takes only 4 of the 9 justices to decide that they want to hear a case. If 4 of the 9 say that they want to hear the case, then the Supreme Court will hear the case. That is called the Rule of 4. The Rule of 4, again, means that it only takes 4 of the 9 justices to grant a writ of cert and say that they want to hear the case. So, all of that was part of step number 1. Now we move on to step number 2, and that is this. After the court grants cert, they send out a letter to the people who had petitioned the court, and the letter says basically, congratulations, we are going to hear your case. And they request something very special, and it is called a formal brief. each side submits a formal brief. And the formal brief includes the argument that they're making, or are going to make rather, before the court. It's basically about 25 pages long, and it says, here's why my side should win. And it lays out their entire argument. So why is this important? Because before we get to the next step, step number 3, before we get there, the justices already know what both sides are going to argue. It's like the ultimate spoiler. Each justice knows what each side is going to argue before they even hear the argument. Which brings us to step number 3, and that is called oral argument. This is the part of the process that we hear about, because this is the part of the process, the only part of the process, that the public has access to. We can go to the Supreme Court and see a case argued before the court. So, oral argument is step 3, and that is the day in court that each side has. So, when a case is heard at the Supreme Court, each side gets, you ready for this? 30 minutes. And that is it. Each side who's making their oral argument before the court gets only 30 minutes to make their case. The process is, as we say, conversational in tone. So what we see is one attorney standing at a lectern and making their argument to the justices why my side should win. But remember, the justices already know the arguments that are going to be made before them. And any justice can ask any question at any time during oral argument. So usually when I'm in a class making this point, someone will raise their hand and they'll say, you mean so any justice can just interrupt somebody and ask any question they want? Yes, the answer is yes. And then I get this question. Excuse me, so what if the justices take up all that person's time by asking questions? Does that eat into their 30 minutes? Yes, it can take their entire 30 minutes. So that's, believe it or not, the point. When I say conversational in tone, I mean a justice will ask a question and the lawyer will say, oh, Your Honor, that's a very good question. Thank you for asking. And then they'll answer the question, and then another justice will jump in and say, oh, well, what about this? And they say, oh, well, thank you, Madam Justice. That's a really great question, and here's my answer. So that's what the process is like at oral argument. But remember, since the justices already know what argument either side is going to make, ready for this? The justices, a majority of the time, already know how they're going to decide on that case. So why, then, do we go through this process of oral argument? Well, the answer is that this is, as I just mentioned a moment ago, the only part of the process which the public has access to. What does that do? That creates an air of legitimacy for the Supreme Court. Without oral argument, the entire process would take place behind closed doors.